Any police case has been registered?
My lord, it is not mentioned in here, my lord.
Last paragraph, paragraph 10.
The one civil
Only inquiry.
is pending here, my lord.
One
Already.
civil case is
So
just-
the WPC criminal is not maintainable.
Yes.
The
My
client
lord,
is under.
my lord, my prayer is only, my lord, not to harass the petitioner without registering any case, my lord. Police suddenly visited the house of the petitioner on 25/5/2024 at 1 p.m.
A.M. Ahmed, learned counsel for the petitioner, also heard Mr. P. Sharma, learned G. Assam, who has obtained instruction as per the order dated 14/6/2024 passed by this court and produced the same before this for perusal by the court. Full stop. A perusal of the instruction furnished by Superintendent of Police, Dorong, Mangalday, goes to show that although an FIR has been received against the petitioner, yet no police case has been registered against him till today. Full stop. The instructions further reflects that a preliminary inquiry is going on so as to ascertain as to whether any cognizable offense is made of from the FIR, and until the matter is ascertained, Mr. Sharma submits that no further action is contemplated against the petitioner in this case. First of all, in view of the above and considering the limited nature of relief prayed for in this writ petition based on apprehension of arrest, we are of the view that no further order is called for in this proceeding, save and except providing that action, if any, proposed against the petitioner shall be initiated strictly in accordance with law. With the above observations, this writ petition stands closed. Copy of the written instruction dated 24/6/2024, furnished by the SP Darang Mangaldoy, be retained in the record.
Okay.
Is missing in লাগিছে মোৰ ইনস্ট্রাকশনটো যদি আমি রেকর্ড কৰিলে suddenly আৰম্ভ
May I please, your lordship? This is a contested matter, my lord.
কোন আদারওয়াইজ একটু রেকর্ড করলো না আবো
Yes,
My lord, this is the contested matter, my lord.
contested matter. Yes, Ms. Verma.
Notice, Lordship can issue notice, Lordship.
All right, heard Mr.
S.I. Talukdar.
S.I. Talukdar and counsel for the petitioner. His writ petition is directed against the opinion dated 14/7/2023, passed by the learned member, Foreigners Tribunal number 1, Gwalpara, in connection with FT case number 8190/G/16, declaring the petitioner as a foreigner of post 1971 stream. Mr. Talukdar submits that it is a contested matter, and although the petitioner had adduced evidence, the same has not been appreciated by the learned tribunal in proper perspective. Appreciation of such submission of the petitioner's counsel would require perusal of the records by this court. As such, issue notice returnable in 6 weeks, since who is appearing for the Union of India? Since Mr. R.K.D. Chaudhary, learned DSI,
কে গগৈ
Mr. K. Gogoi, learned CGC, has accepted notice for respondent number 1, Ms. A. Verma, learned SC, Home Department, Government of Assam, for respondent numbers 2 and 4, Mr. P. Sharma, learned G. Assam, for respondent number 3, and Mr. A. Ali, learned Standing Council ECI, for respondent number 5. Service of notice is deemed to be complete on respondent numbers 1 to 5. Extra copies of the writ petition be furnished to the learned department council requisite in numbers so as to enable them to obtain instruction. Petitioner to take steps for service of notice upon respondent number 6 by registered post with ID within a week from today. call for the LCR. Is the matter again after receipt of LCR?
The interim petition may be given.
In
Interim.
2023.
Lordship,
2023.
let the records come, Lordship.
Let the
After
records come.
receipt of the records,
Therefore,
interim may be
interim
considered.
immediately on the-
Earlier.
Maybe the lordship. So this is also constitutional matter, lordship. Here, lordship, the opinion is page 99, lordship. So, lordship, I have submitted my grandparents' document, father, parents' document, lordship. There is sufficient document, lordship. My
So
one,
order can be passed, Lordship.
so my humble, entry may be granted, lordship. My one cousin also become Indian, lordship. I have also educated him, lordship, and documents also submitted there, lordship.
What is the date of the order?
9
Order
to
is-
2024,
Yes,
Lordship.
lordship.
Right, you take down, heard Mr. S. Hawk, learned counsel appearing for the petitioner. The order dated 9/2/2024, passed by the learned member, Foreigners Tribunal number 3, Nalbari, in connection with FT case number. What is the case number?
Yes, number, lordship. FT null, top lordship, FT bracket null, lordship 3. This is the lordship. 7121.
F full stop T full stop bracket out NAL N capital NAL bracket close dash 3. Case number 71/2021 has been assailed in the writ petition by the impugn order passed by the learned tribunal. The petitioner has been declared as a foreigner, declared to be a foreigner of post 91 script. Mr. Hawk submits that the learned tribunal has failed to appreciate the evidence adduced by the petitioner pertaining to his lineage. It is also the submission of Mr. Hawk that the father of the petitioner has already been declared to be an Indian national, is it?
Yes, lordship.
Full stop. Since it is a contested matter, we are of the view that perusal of the records will be necessary. Stop as such. NOM 6 weeks since the same both. Mr. Gugoi, K. Gugoi, correspond number 1. Ms. A. Verma, Learned SC, Home Department, correspond numbers 2 and 4. Mr. A. Ali, ECI, SC, ECI, correspond number 3. And Mr. P. Sharma, Learned G. Assam, correspond number 4, service of notice. When respond numbers 1 to 5 is deemed to be complete in this case. Extra copy of the writ petition, requisite in numbers, be furnished to the learned department council so as to enable them to obtain instruction. Petitioner takes steps to the service of notice upon the respond number 6, the registered post with AD within a week from the day. Call for the LCR. List the matter immediately upon receipt of LCR.
Interim apparently may be granted, lordship.
Interim, what interim?
Lordship, I may not be arrested and detained. I may not be arrested, lordship. This must only, lordship.
After receipt of the LCR, Lordship. It is just 1 month old order. LCR will be here in 6 weeks, maybe 4 weeks. Lordship has issued notice returnable.
But this is a recent order. The
Yes, sir.
other one was very old order.
I leave it to Lordship, but otherwise, after receipt of LCR is better.
We don't understand what is
Supposing
happening.
Lordship
The
interim
English
is
type
granted,
Lordship.
then this matter does not get listed fast, Lordship.
No,
That is,
we'll pass an order. See, that's not the point. Point is the courts must have a transparent and consistent standard. You can argue
yes, Lordship.
anything that suits, but we as courts, we have to follow a transparent and consistent standard. In other matters, recent,
Lordship, my colleague is suggesting,
Grant bail in this
yes.
case, my lord, they may appear before the SP concerned and give their thumb impressions and my lord IDs so that their records may be available in the.
Lordship,
SP.
the order has to be clear. They have to take
are the
bail.
prayer of interim relief. In regard to the facts and circumstances of the case, it is hereby provided that in the event of arrest, the petitioner shall be released on furnishing a bond of rupees 5,000. And subject to the further condition that the petitioner appears before the concerned superior of police within 4 weeks from today for recording his fingerprints and IDs of and IDs of eyes. What is it called? IDs of
Iris,
eye
capture the iris, Lordship, only the iris.
and for capturing the iris.
Yeah, lordship.
Hmm. Hmm. This.
Please, Lordship. This is a contested matter, Your Lordship. Opinion at 122, whereas the petitioner has submitted all the documents along with the headmaster's evidence, Lord Mondal, as well as the ward commissioner. Her own sister also deposed, mother's
Mr.
husband.
S. Ahmed, counsel for the petitioner, assailing the order dated 24/2024 passed by the learned member. FT of Nagav.
Yes, Lord.
I think the last few days back also you have again filed a writ petition without proper
I
particulars.
have rectified it, Your Lordship.
But where is the case number in your synopsis? Who has passed the order?
Lordship. The last,
Clarification?
last,
Which tribunal has passed the order?
this has been passed by the number 1 Nagaon, Your Lordship.
Why have you not mentioned it?
It has been mentioned in the synopsis, Your Lordship.
It's not.
Where is it? Let us see.
It's not there.
Earlier, it was not there. I have just went there and after the last order was passed, I have corrected the other one.
You have mentioned it.
I have
Okay,
corrected
where
the,
is it? This shows. Tribunal number? Foreigners Tribunal number 1 Nagaon. Passed by the FT number 1 Nagaon in connection with FT case number 1395 of
It's not
11
corrected, okay.
bracket D, declaring the petitioner to be a foreigner of post 1971 stream. Mr. Ahmed submits that this is a contested matter. First of all, although the petitioner has adduced sufficient evidence in support of a citizenship claim, the same has not been considered in the correct perspective by the learned tribunal. Issue notice returnable in 6 weeks. Since Mr. K. Gogoi, learned CGC. M. Kalita. He is not appearing. Take down CGC, respond number 1. Ms. A. Verma, Home Department, Lihibo for respond numbers 2 and 3. Sharma, Jiasam for respond number 4. And Mr. M. Kalita, SCECI for respond number 6. As such, service of notice upon respond numbers 1 to 4 and 6 is deemed to be complete in this case. Extra copies of the writ petition be furnished to the learned department counsel is to enable them to obtain instruction. Petitioner to take steps for service of notice upon the respond number 5, that instant post will be within a week from today.
Yeah.
Call for the LCR. This the matter again immediately upon receipt of LCR. Pardon the prayer of interim relief. Having regard to the facts and circumstances of the case, it is hereby provided that.
all blessed.
May it pleases your lordships. Lordships is a contested matter. Order is at page 35. And after that order was passed, we have filed the review petition also before the Foreigners Tribunal, Kamrup Metro number 4 lordship. And
Review
the
on what ground? Review on what ground?
there are lacunas in annexures, like in inquiry form was not properly filled up, lordship, and her place of birth of place is written as Meghalaya, which is not a specified territory, lordship.
Mr. Pine, we'll have to call for the record.
Yes, your lordship.
What order, what else do you pass in these cases?
Your lordship may protect them, my lord, they may appear before the speaker. This is Kamrup Metro.
Kamrup.
DCP border and same order maybe.
All right, take down. Heard Miss H. Betala, Learned Counsel for the petitioner. This petition is preferred against the order dated 23/2/2024. Original order is 23 to
23 to 2024, lordship,
Passed by
and
the Learned
thereafter
Foreigners Tribunal number 4 Kamrup bracket M bracket close Assam in connection with F full stop T full stop bracket DV bracket close. What is DV? Domestic violence.
no lordship, doubtful voter.
Doubtful.
Bracket close. Case number FTK bracket M in the side of it. The 4th 2018, declaring the petitioner to be a foreigner of post 1971 strain. Ms. Bethala submits that the Learned Tribunal has failed to appreciate the evidence in the correct perspective before issuing the impugned order, and therefore the order under challenge suffers from perversity. We have perused the materials and records of issue notice returnable in 6 weeks. Mr. K. Gogoi, Learned CPC, has accepted notice for respondent number 1. Mr. J. Paying, Learned Standing Counsel, Home Department, also bracket FT, bracket case for respondent numbers 2 and 7. Mr. A. Ali, Learned SCECI for respondent number 3. And Mr. P. Sharma, Learned G. Asam for respondent numbers 5 and 6. J. Paying to the board, 2 and 7. 2 and 7. As such, service of notice upon respondent numbers 1, 2, 3, 5, 6, and 7 is deemed to be complete in this case. Extra copy of the petition will be furnished to the Learned Department Council first to enable them to obtain instruction. Petitioner to take steps for service of notice upon respondent number 4 by registered post within a week from to stop. Call for the LCR. Let this matter be listed immediately on receipt of LCR. Third, on the prayer of interim relief, having regard to the facts and circumstances of the case, its entirety, is hereby provided that in the event of arrest, the petitioner shall be released on bail on furnishing a bond of rupees 5,000, subject further to the condition that she appears before the
Biometrics and iris, my lord.
respondent number. Before the superintendent of police. Border,
DCP border.
ACP border, Kamrup, bracket camp, within 4 weeks from today for recording our biometrics and iris of the biometrics and including the iris.
Lordship, this case is an where the ex parte order was passed. And the petitioner a petitioner received the notice as on 2/7/2019, Lordship. And
We will
on,
keep it in motion and records. Mr. Pai.
Yes, let the records come and keep in motion.
yes,
Admin Butler and counsel for the petitioner. This petition is directed against the ex parte order dated
11/2020. 1/2020.
6/1/2020, passed by the learned member Furnace Tribunal from Buxar in connection with FT case number 114/Buxa, capital Buxar, /2019, declaring the petitioner to the foreigner post 1971 stream. Ms. Bethala submits that no notice of the proceeding was ever served from the petitioner, and hence she is highly aggrieved by the impugned order. Having heard the counsel for the petitioner, we are of the view that perusal of the LCR would be necessary in this case. Register to therefore call for the LCR. Let this matter be listed again for motion immediately on receipt of LCR. Mr. J. Payne, Learned SC, Mr. P. Sharma, Learned G. Asam, and Mr. Yali, Learned SCECI are present on behalf of the official respondents. Heard in the prayer of interim relief, having regard to the facts and circumstances. So she has not been arrested since 2020.
Yes,
The prayer
Lordship.
for interim
Interim-
relief will be considered on the receipt of LCR.
May I please, your lordships? Your lordship, this is a writ petition against ex parte order, your lordship. However, it is not ex parte in the true spirit, as because your lordship, the petitioner appeared before the tribunal. However, he did not get the opportunity to file WS, your lordship. An ex parte order was passed. Subsequently, a review petition was also filed. That was too rejected, your lordship.
Let it notice.
But Mr. Your name, please?
Mr. A. N. Iqbal, your lordship.
A.
A. N. Iqbal.
Yeah, the counsel. A and Iqbal Land Council for the petition. The order dated 28/4/2022. Last busy landed member Foreigners Tribunal Kashmir number 5 at Prisona Charlie in connection with FT case number BLC public D public 1517 public 2016 is under challenge in this petition. Mr. Iqbal submitted that although the petitioner had appeared before the learned tribunal, he was not granted the opportunity to file a written statement, as a result of which serious prejudice has been caused to the interest of the petitioner. If the submission of the petitioner's counsel is to be accepted, then it is possible that the order dated 28/4/2022 will be treated as an ex parte order. Said aspect of the matter can be ascertained only after perusal of the LCR. As such, call for the LCR. Please this matter again for motion after receipt of LCR. So the level of presence to.
Your lordship, till an interim protection he has not been detained, your lordship.
This order is of which year?
2022.
What has happened? Nothing has happened. Interim, you have to make out a genuine apprehension. They have not arrested your client for more than 2 years. They're not interested. Therefore, interim will have to be considered immediately on receipt of it. Considered after receipt of it.
Obliged, your lordship.
This is contested case, my lord. The impugned order starts from page 93. At page 96, the relevant portion.
But Mr.
the-
Overloscal and counsel for the petitioner, this petition is directed against the order dated 18/11/2023. As by the learned member, Foreigners Tribunal number 5, Silchar, Culture, in connection with FT case number 299/2016, declaring the petitioner to be a foreigner of post 1991 scheme. Mr. Loskar submits that this is a contested matter, but the learned tribunal has failed to appreciate the evidence adduced by the lead petitioner in the correct perspective. Mr. After going through the materials on record, we are of the view that perusal of the LCR would be necessary in this case. Yes, issue notice returnable in 6 weeks. And you said, the K. Gogoi learned CGC has accepted the notice for respondent number 1. Mr. J. Payang learned SC Home Department bracket FP for respondent numbers 2 and 5. Mr. A. Ali learned SCCI for respondent number 3 and Mr. P. Sharma learned GSL for respondent number 4. Service is deemed to be complete in this case.
Interim protection. my lord.
Trade copies of the petition before the stipulated department council. Requisite in numbers so as to enable them to instruction. Let this petition be listed again immediately on receipt of LCR. Pardon the prayer of interim delivery to COVID. In the event of arrest.
Protection given.
Lordship, LCR not receive lordship.
Third learned counsel for the parties, it appears that the LCR called for by this court has not yet been received from the Foreigners Tribunal number 1, Lakhimpur. Awaiting the LCR, let this matter be listed again in the third week of April. Was to give one final opportunity to the learned FT to transmit the LCR. First of, if the records are not received before the next date fixed, registry will furnish a report as to the reason why the LCR has not been received despite orders passed on this by this court.
Lordship, earlier interim order was passed, Lordship. It may continue.
Interim order passed.
Yes.
Lordship, against the impugn ex parte order we have come, my lord. We've received notice, but due to ignorance of legal proceeding, instead of engaging a lawyer, we went to the Gaubura, your lordship. Gaubura assured that our name will come up in NRC. But your lordship, it didn't come up. And in the meantime, police is searching for us, your lordship. That's why, lordship, we'll face the trial.
Statement police is searching.
Yes, para 16, your lordship.
The expert will call for the record then.
Yes, let the records be called.
At least BVL and.
In the motion states it.
Conciliatory petition. Petition is directed against the expert order dated 29/12/2020. Passed by the Learned Furnace Tribunal of Baksa and Tamilpur. In connection with FT case number 1974 of the Baksa public 2016. Declaring the writ petitioner to be a foreigner of post 1971 stream. And Ms. Bhuya submits that the ground on which the petitioner had failed to appear and contest the reference case has been indicated in the writ petition. Contending that the petitioner deserves a chance to contest the reference case so as to establish a citizenship claim. Ms. Bhuya prays for an order setting aside the ex parte order dated 29/12/2022. To stop the prayer made by the petitioner's counsel can be considered only after perusal of LCR. As such, register to call for the LCR. List this matter again after receipt of LCR. Hard on the prayer of interim relief. Mr. J. Pang, Learned SC Home Department Assam. Mr. P. Sharma, Learned GA Assam, and Mr. Ali, Learned SC ECI are present and have been heard. Considering the facts and circumstances of the case, and more particularly the averments made in para 16 of the writ petition, as an interim measure, it is hereby provided that in the event of arrest, the petitioner shall be released on bail on furnishing of bond of ₹5,000. Subject further to the condition that she appears before the concerned superintendent of police within 4 weeks from today for recording her fingerprints and iris.
Interim, your lordship,
Yes.
my lord. And next,
She has to appear within 4 weeks
we'll
for
appear.
recording her fingerprints and iris.
Yes, ma'am. Lordship, para, next, yes, that para 15 we have stated.
Para 15.
Same.
Same thing, para 15.
Yes.
My lord, on the last occasion, the state government, the state respondents were directed to file a detailed affidavit bringing on record the medical records as well as the police investigation report. So we prayed before the court, honorable court, to allow us to apply for a certified copy. We have received 3 certified copies yesterday itself, my lord. One certified copy is yet to be received
You are appearing for whom?
for the state respondents, my lord.
State government wants permission of the court to apply for certified copy.
We have already obtained that permission. We've received 3 copies of the certified copy yesterday. 1 copy, that is the case diary along with the medical report. That some clarification is sought for by the copying section. That is why we couldn't receive that copy yesterday. We may be allowed some time, maybe. I don't know.
Is there an interim order in your case?
No, my lord.
What is this matter about? Mr.
My lord, a minor boy was picked up by the police, my lord,
Hmm.
to the police station. He was kept in the police station overnight. He was mercilessly beaten. And my lord, he was subsequently shifted to the hospital. treated in the hospital.
Speak a little louder, please.
He was shifted to the hospital, my lord. He was treated there, and my lord, presently, my lord, he is still not recovered from that trauma, my lord. He has, my lord, developed neurological disorder due to the, my lord, merciless beating of the police in the police station. But he was minor at the time when he was picked up by the police. This is the facts, my lord.
So she wants some more time to complete her instructions. We'll post it on the day of reopening then,
My lord.
July 15th,
My-
July.
my-
We take down. Mr. Right Seeker and Council appearing for the petitioner, Miss, your name?
You Sharma, my lord.
You Sharma and G. Assam,
Junior Government Advocate.
Junior Government Advocate Assam, appearing for the respond number
1 to 6, my lords.
26 submits that in terms of the order passed by this court, although certified copies of some of the documents have been received in the office of the learned GA. However, some more time is required to complete the instruction. As such, Ms. Sharma has prayed for posting this matter immediately and reopening
On
of the
reopening.
summer vacation. Ms. S. Sharma, and Standing Council
For Health Department.
Health
That's for the
Department.
next.
is present on behalf of respondent number 8 and
So
you are
one
Mr.
to-
P. Roman for 7 and 8 to Lovadigo. On the request of learned counsel for the respondent number 1 to 6, this matter is directed to be listed again as a fixed item on 15/7/2000.
Highly obliged, my lord.
Item 12.
Yes,
Yeah, your lordship, my lord, the procedure has already died. So
procedure has already died.
matter may be kindly closed. That is a death certificate.
Mr. M. Mohammed Learned Counsel for the writ petitioner submits that the proceeding, that is the writ petitioner, has expired on 6/2/2024. And the legal heirs of the petitioner are not interested to pursue this matter before this court any further. As such, the writ petition be closed. Mr. J. Pine and SC Home Department Assam, Mr. P. Sharma, Planet G. Assam, and Mr. A. Ali and SC PCI are present and do not have any objection in view of the above. This writ petition stands closed. Interim order, if any, shall stand vacated.
Right.
Item 30.
May I please, your lordship. Lordship, the petitioner has already been died in 3 to 4 months back, lordship, but I have not received the death certificate yet, lordship. I have informed the petition as husband of the petitioner.
Receive instruction.
Yes, lordship.
All right, then we'll close it. Your name, please?
M.S. Alam.
Mr. M.S. Alam, Learned Counsel appearing for the writ petitioner, submits that the petitioner, that is the proceeding in this case, has expired a few months back as per instructions received by him, and therefore, and the legal heirs of the petitioner are not interested to pursue this matter before the court any further. As such, the writ petition be closed. How's it time to go, Namdevo? Taking note of the submission of Mr. Islam, this writ petition. Is there any interim order here?
Yes, lordship, there was.
Interim order passed away. Shall stand vacated.
Obliged, lordship.
My lord, in item number 10, my lord, there is an order your lordship has passed because the LCR was not there. LCR was not there in that case. There is some problem in the, my lord, I have talked to the tribunal and tribunal has written a letter, probably that was not properly placed last occasion, my lord. Tribunal has said the case number which has been given is of a different person, my lord. The tribunal has written a letter, my lord. So the tribunal unable to send it. The FP case number 307/2010. It relates to some other person.
No, but tribunal has to send the
That-
records. Whether it is this correct record,
Yes.
wrong record, that is none of the business of the tribunal.
No matter the party name is different there. That's why probably tribunal is unable to send it. Jibon Devnath is not, the party name is National Begum.
There are consequences will follow. Tribunal has to send the record.
Obvious.
No, I think states, the state. Yes,
Item four, city measure, item 14 and 15.
আমি এফালে May it please your lordship.
yes, please.
In fact, this is the third time I am starting the hearing. Twice I have completed about 5 days, 6 days continuous hearing before two different honorable chief justices. Before my lord Justice Dhulia, it was heard completely, and before my lord Justice Mehta also.
Both of them have moved on.
On their reply time, the honorable judges got elevated.
Yes, I was also throughout the proceeding, we were there. I think some 15 days time, then again, we also took.
There also day-to-day hearing took place.
Day-to-day hearing to has taken.
But only thing is that lordship, I can start the case. I am prepared also, but I won't be able to finish it today. Because I have to leave in the second half, lordship. So whether lordship would like to start in piecemeal today, because and after my reply, they would also like to reply. And there are several chapters. I can start. I can cover 2-3 topics today itself, but it will not be completed. And from tomorrow, lordship, I am not here. And I was waiting last week to complete the hearing because my instruction that I have to argue on Wednesday, Thursday, and Friday. I accordingly kept myself free. But somehow it got prolonged. Anyway, that is beyond lordships, because they want to continue hearing, then they always have to get the opportunity.
You are not available in the second half.
No, lordship, I have a flight at 4 o'clock today. But
You are flying around, but what do we do?
no, yesterday also I was doing online case. Day before yesterday also online cases. I may be outside, but from tomorrow onwards, in my time zone will be totally different.
You start, let us
Lordship.
see what happens.
Because our reply will be also very important, my lord.
No, if
No,
you cannot complete, then it's going
Then,
up to the vacation.
yes. Mr. Only one request has been made by Mr. Chaudhary also, can ensure that we will also like to give a reply. Remember, he is busy in the election. Because reply is more important, what I felt.
In that
We have to
case,
hear first.
Reply subject to his completion.
No, that's right. But we reply was subject to his completion, but reply is more important, what I feel.
No, everything is important. but
Yes.
Yes, reply will be there.
so first I'd like to take the topic.
Mr. Saikia, last two occasions, the problem you faced will not happen now. So you can safely start
And I do not,
finish.
I foresee a lot of things, lordship. Everything is uncertain. Maybe double promotion may not be there.
So this time you are assured that that is not happening.
But this is good for the other side, lordship.
Yes, yes.
When it is the same things going on and on, it's always beneficial to them. But for the government, lordship, no, only one time.
Okay.
I'm not on that, by the way. I love arguing the case. And in fact, I remembered all the sections at that point of time. But today I have to refresh everything anyway. So basically, lordship, the cutoff topic.
So give us a feel of what is the government's, instead of going into the nitty-gritties.
There are two cutoff dates. One is regarding.
Before you start, Mr.
Yes.
Saikia. We wanted last occasion, I think we mentioned it
Yes, Lord.
to Mr. Majumdar also. These legislations, we find that broadly there are three aspects. What view the court takes is a completely
Lot.
different matter. On the touchstone of constitutional principles, only these issues can be examined, nothing else. But we have found that this has got a prognosis. This case or this controversy has a prognosis. There was a time when there were some acts, rules framed and regulations framed to run the affairs of this kind of colleges, LP schools, etc. And there are a large number of venture schools which are completely private schools set up by private individuals over private property. Then comes your 2009 Act in the sequel of Article 21A, which makes right to education of a fundamental right for a children of that particular age group. We are mentioning this because we are trying to understand
Yes,
what
Lord.
is the true constitutional spirit. What happens, we'll see, but it is important to understand the true constitutional spirit. So Constitution says the state has to provide education, primary education to this category of students free of cost with all these amenities. And that is embodied in the 2009 Act. Now, once the Act comes, the state overnight cannot come up with so many schools. It's not possible. So probably, if it is the case, we don't know, but probably one way of doing it was to take over some of the venture schools, colleges of different levels, or if not the entire school, at least some posts, some teachers. And that is why probably the 2011 Act also makes an attempt to be in consonance with the requirement of 2009 Act and the 2011 rules framed by the state.
Lordship.
Now, 2011 Act lays down certain
11
criteria,
rules.
X, Y, Z, but section 4.2 and 10.4 of that Act was put under challenge, right?
Yes.
Now, ordinarily, this we are telling you because we are trying to put things in perspective. Otherwise, it will be a very long and arduous chapter of debate and deliberation, which is of no use. Now, normally, an act of the legislature, it's a plenary act. It's
Lordship.
not a delegated legislation or a subordinate legislation. A plenary act, to our knowledge and understanding, can be interfered with only by two constitutional mechanisms. One is either the court strikes it down. For doing that, the court has to come to finding that these are the lacuna in the act, therefore it suffers from constitutional failings. Having done that, the court has no business in saying anything more. That is not within the domain of court. The court can either affirm the act, strike it down, or read down some of its provisions. These are the only three options available to our understanding
Lordship.
insofar as the court is concerned. Other than that, it is either a repeal of the act or replacement of the act by the legislature itself by enacting a fresh law. But in this case, it prima facie appears that a somewhat hybrid approach has been adopted. Court has struck down the act, but taking note of a concession made by Secretary, I think Commissioner Education has filed some affidavit, if we remember correctly. And then the court says the government has accepted. And then, of course, some 2-3 paragraphs, some reasonings have been given. Now, the court strikes down the act, then the state comes with a review. Ordinarily, Clause 6 of General Clauses Act, either the Central Act or the State Act, would kick in the moment the act is struck down by the court. If it is replaced or repealed by the legislature, then also it kicks in. But the state comes up with a review application saying that what will happen to those people who have been already provincialized? That was a time the spectrum had about 72,000 teachers across the state, a lot of whom were already provincialized, and a good deal of them were either in the process of being provincialized or their selections had taken place, but the formal expression of the order of provincialization were in the pipeline. Around that stage, this happened. So the state comes up with a review petition saying that please tell us what happens to those who have already been provincialized. So the court does not give any specific direction, but merely says it will be for the legislature to give retrospective effect to the legislation. Then comes the new Act of 2017, where in section 24, the saving and repeal clause, there is a mention that the court has struck down, etc. And insofar as those who have already been provincialized, they will continue subject to, there is a provisional. So here what we find that those who have been provincialized, the government comes and says, please save their appointment. And then their appointments have been reopened. That their continuance will be subject to recommendation by the committee formed under the Act. Of course, the learned departmental council could not tell us which is that provision under the 17 Act under which this exercise, if at all, is to be done. But that is another matter. But here we find that although there is a statutory provision in General Clauses Act that all these will be saved, the state comes with a request to the court to clarify. The court does not say anything. The repeal clause mentions about the court striking down and reopens their appointment, which prima facie appears to be contrary to the spirit of Section 6 of the General Clauses Act. Then what we find is the broad issues are, as we could gather from the arguments, are mainly threefold. The first, they are saying that 1/1/2006 cutoff is fine. It's fine with us, but how can you make a distinction between those who got the formal order before 1/1/6 and those in whose case the formal order was delayed merely because there was a ban of recruitment or orders, etc. And to that extent, the challenge is to 3(1) subrule 1 of the amended provision 2018. So here the argument is of discrimination, making two classes without any intelligible differential, because according to them, this is a process which the petitioners can't be blamed. If the department took longer time or for whatever reason, provided they meet the same regulation, same requirement as the ones who have been merely because there was a delay in formal expression, how can you deny them? This is the number one argument. Number two is that the object of the Act is to streamline and to stop mushrooming. These are the two main arguments. 2017 Act, unless one says that this idea of 1/1/2006 cutoff is an idea to stop it, there is no provision which actually directly aims at preventing mushrooming of these venture schools. Rather, documents have been given to us to show that fresh permission applications are still being invited. We don't know whether it is this or some differences there. Maybe you will be able to clarify. So this is one category. Second category of argument broadly is that by providing for maths, language and English teacher, you are omitting teachers of Arabic and other MIL, etc., which is affecting a particular class of institutions in the sense that the conditions for additional posts to bring these people in, we have served more than 20-30 years, is very, very onerous. And therefore, indirectly, the state is stopping few subjects from being promoted. And it is the madrasa category, ME madrasas, who are basically agreed with this. So they are saying that you are, and in MIL also, I think the argument was, the mention is of Assamese, Hindi teacher is also omitted. In some areas, MILs could be other languages. In Barakvili could be Bengali, somewhere it could be Bodo. So is the idea that some subjects should be clipped? If it is the case, then it has got no reasonable nexus with the object of the Act. This is one limb of argument. Another limb of argument is that tutors. The argument is that you can very well prescribe that after coming into effect of these acts, unless you fulfill these qualifications, you will not be entitled to certain career advancement. That the state is very well empowered to do it. And to that extent, tutors are those who do not have B.Ed degree. That's fine. But if all these provincialized employees are to be treated as government employees, how can you treat some category of government employees permanently on a fixed pay stipend? A government employee will have to be on a permanent employment because there is a question of pension, there is a question of other elements, and there is a question of DA enhancement pay. This is what is associated with a government employee. So you may say that people who have B.Ed will be entitled to a bigger grade pay, more career advancement. But certainly because a category doesn't have B.Ed, of course there is a window that within 5 years you can complete it, but the very many will not be able to complete it. Still they will remain government servant, but tutors, that's also okay. Nomenclature doesn't have any difference, but they will have to serve the rest of their lives on a fixed pay. So will they not get any pension? If they don't get any pension, if they don't get any DA, if they don't get a pay scale, then first of all, how are they to be treated as government servants? Secondly, this is not provincialization within the meaning of the act. Provincialization is defined under the act as they will be government servants for all practical purposes. We are recapitulating the areas
Yes,
where
Lord.
you will have to throw some light. So to that extent, the challenge is that you have to give them a pay scale. That can be less, that can be more, that is another matter. That the state is empowered. Then, of course, in the colleges, they are saying the ratio you have proposed is totally irrational in the sense that because of this ratio, student-teacher ratio, people who have been working for 15 years, 20 years, 30 years, they will be totally obliterated. So to sum it up, the argument is that, all right, if the intent and object of the act is that up to a particular cutoff date, we take in people and thereafter we stop completely. Then how does the object of the act, the old act, how does it deliver on these counts? And then, of course, there are arguments of repugnancy.
No, this is object, the previous one, Lordship.
It is not in consonance with the object of the act.
Okay.
Object of the act, it is not in consonance. And it offends a number of provisions which Mr. Majumdar must have noted of the RTE Act 2009, the rules of 2011, and therefore these are not the institutions which got the permission in 1999. How can their teachers be withheld only because the formal expression of the permission came after 1/1/2006? Then there is a batch of writ petition. Mr. Manish Goswami, I think, had appeared. They were music teachers. Their cases, they were all subjected to the scrutinization by the committee, district committee. Their names were forwarded. The director forwarded the name. It went to the government. Thereafter, it got stuck up. And then this proviso came in, Rule 311. And then the government says, sorry, your permission was not received. The government did not approve. So there the argument is that everything was over before 1/1/2006 and the government has delayed the matter. So how can that be a ground to take away our rights? How can that be a ground to delay our rights? And to top it up as a whole, the argument which has evolved, we won't say any council has specifically argued this, but we can say that this point evolved, that there is a deeming fiction. Of course, Mr. K. N. Chaudhary has argued on this point, that there is a deeming fiction under section 4(1). which refers to provincialization of persons who have already been provincialized or who are going to be provincialized under the Act. So going to be provincialized according to the councils appearing in the different writ petition means that only thing is, it is a matter of fulfillment of the 7 years period. Those who comply with all these conditions, complete 7 years and there is nothing against them, they will be deemed to have been regularized by efflux of time due to operation of statute. And therefore, they had an accrued right under the previous act. That right has been sought to be taken away by 311. So that is unconstitutional. There is a deeming fiction, there is a question of accrued right. This right is not merely a hope or expectation, but they have been subjected to the district scrutiny committee's verification. Then recommendations came in. And finally, before the final order of ministerial nature was issued, this ban came in. And now they have been excluded. So therefore, it abridges their fundamental right of taking away the vested right under the law, which is a ground some decisions have been cited for the court to interfere. In a nutshell, these are the broad.
So I have to start with cutoff date, Lordship. And I have,
Whatever suits you.
in fact, I have dealt with all these points in the earlier rounds. But I have to take your Lordship to some of the writ petitions. Because the stand which they are taking, that they got the permission in 1999, and because of some ban period, they are not getting the recognition. There are annexures in the writ petition itself, which says 2 months ago, 3 months ago, prior to that cutoff date also, regularly recognitions were granted. Recognition itself cannot be, it is not a mere formality. Once the permission is granted, then there is a sequence of events. They have to comply with certain requirements, like the number of classrooms, schools, the students, etc., various facilities in the school. Until and unless they complete that requirement, their recognition is not granted. So it keeps pending. So when somebody did not get the recognition on 1/1/2006 and they got it in 2009 or 2010, maybe their permission was approved in 2019-98 or maybe 2002 also. That does not mean that they have the recognition, the condition precedence fulfilled on the date of the cutoff date. From their own records, I can show. So it is not that government did not apply its mind. Government had applied this mind, and in the earlier act also, the same cutoff date was there. If we look at the overall perspective of this act legislation, Lordship, is the government under any constitutional duty or bindings to provincialize these private schools? Absolutely no. It is a huge financial burden on the government. And there is no shortage of school under the RTE Act also. It is not that government provincialized this school just to bring and fulfill the requirements of RTE Act of 2009. RTE Act is very limited. It is only limiting to the students and the classes of elementary education. That means up to class 6, class 8. So here there is a mixture of classes beyond class 8 also.
Just one, so I'll just take a leave and I'll come down. He's voting down.
So this cutoff date, Lordship, whatever may be the cutoff date. Today the act was brought in 2017. If we change the cutoff date, then there are a lot of persons who will come with a recognition of 2015 also. And if the cutoff date is today, there will be other persons who will bring the cutoff date.
No, just one interruption here. Nobody is saying change the cutoff date. The question is not before the court. Cutoff date has to be 1.
Yes, Lordship. Lordship, there is an advertisement for employment. Last date is 31st December. I appeared in the examination in the month of November, and my result is declared in April subsequent year. On that day, I was not eligible.
The persons who acquired the qualification prior to that date, they are qualified. That same principle will be applicable here. When we have decided, this is a policy decision. So we have to look at our budget also when we are going to provincialize these schools and the teachers. So we have to have various factors into consideration when formulating this act in 2011 as well as 2017. With our limited budget, we estimated that this much of schools have got a recognition on a particular date and the permission prior to that. So that assessment has to be done. Otherwise, this act could not have been brought into force in 2011. In 2011, the flaw was that those persons who are going to be provincialized, they do not fulfill the requirements of the various acts and legislations of the central government regarding their eligibility criteria. En masse, everybody was provincialized without having the B.Ed degree, without having the graduation degree, without having other qualifications as regulated by UGC Act, UGC regulations of 2010 or prior thereto, or under the NCT Act of 1993 and the subsequent state acts of 2003, the higher secondary education rules and regulations. All these basic eligibility criteria were not considered. They were never taken into consideration, those criteria. Undeserving, unqualified teachers or persons who were working in these private schools were regularized and provincialized thereafter. As a result, the students were suffering because they do not have a proper qualified teacher to teach them. Our experience shows that two brothers have two schools in the same compound. That is why this act is very stringent. The RT Act also provides certain requirements regarding the school building and the facilities that has to be available in the school campus. Here also all these requirements are there. The scrutiny committee not only looks into the eligibility criteria of the teachers, but also the infrastructure side also. It is very easy. Suppose they are unhappy with the this term of tutor. I will be the last person to disagree to that. If they are unhappy with tutors, then what will happen? Those tutors, in fact, we should have chucked them off.
No, they are not unhappy with tutor. They are saying fixed pay.
Fixed pay. In fact, they should not be allowed to enter the school campus also. I'm making a very harsh statement. It is actually this tutor word we have imported just to accommodate these persons. Otherwise, they will be on the streets. If they want to get the pay scale lordship, then we'll have to fight the case in a different manner. Under the various legislation, be it the state legislation or the central legislation, nobody can be working there in the teaching faculty without having required educational qualification. In non-teaching stuff, the story is different. But for teaching stuff, they must have the minimum basic qualification as prescribed under the regulations, whether it is a central regulation or the state regulation.
So, Mr. Saikia, I'm sorry, I'm just interrupting here. You see, the perspective appears to be a little different. Nobody and the court will not and cannot question the wisdom. They are not on the wisdom. The government knows what is the best thing to be done. That is none of our concern. You will have good reasons, but whether the reasons are good or bad, wisdom, we are not getting into that. That's not the...
No, if they are challenging, suppose they are challenging the concept of tutor here.
Listen, the point is somewhere else. So, as you can address the court on other issues, but ultimately the only thing that will matter is this. Therefore, I'm just highlighting it. We are not on the wisdom, whether they should be retained or they should be thrown out. That is not the remit of the court in this matter. The only issue, as I have said, the virus of this act or some of the provisions are under challenge. As you know very well, the constitutionality of a statute can be examined by the read court only on 2 or 3 very well-defined grounds.
And recently the arbitrariness has also been added.
Yes. So they are not saying, why have you named us tutor? That's not their case. And we are just pointing it out, what is their case.
If their case is like that only, if suppose pay scale is there, then this should go to the single bench, that issue. This is before the division because they have challenged the virus of the act. That is why this is before this honorable court. Whether they should get that say amount under a pay scale or under a fixed scale, for that constitutional court or the division bench is not required.
Anyway, you address
Yes.
this point, but
I'll address each and every point in detail because I think they have argued it in a very detailed manner. So I have to take each point individually. I'm giving a broad perspective regarding the other part, Lordship, that repealing and etc. It is very easy for us because when we moved the review application, we took the plight of 41,000 persons who were already regularized, provincialized, sorry, and also some of them have retired, superannuated also. So to save their plight, the government took a humanitarian view. That is precisely the reason why the review was filed, and this honorable court also allowed us to go ahead, keep them, because law is very well settled, as this honorable court has rightly said. Once the act is set aside, all actions pursuant thereto goes lock, stock, and barrel. Nothing can be saved unless there is a specific direction that this act is prospective. This declaration is prospective in nature. But that prospective nature direction was not there. So from 2011 onwards, whatever was done in terms of that act with amendment of 2012 and 13, everything should go. But looking at the plight of these 41,000 people where governments were giving them salaries, etc., all the benefits, and they started a standard living style. So we do not want to upset, and therefore,
since we are on this point, we'll just take 2 minutes. Just come to 24 of the new act. Some clarification here, we can do
yes,
some
Lordship.
homework during the
The
vacation.
repeal and the, I have,
Yes.
yes, may I read it?
Found it a little confusing. Can you throw some light? What exactly is the meaning of this section
The
20?
repeal and savings, the Assam Venture Education Institution Act 2011 as amended by the Assam Advisory Act of 2012 and 13 have been struck down by the Honorable Guwahati High Court on by dated order dated 27/9/2016 in WPC so and so, and all rules, orders, notification issued there and under stands repealed. However, all the teachers whose services were provincialized prior to 23/9/2016 shall continue, and their cases shall be reviewed as per the eligibility norms set forth for the province under this act. This language was basically to give a handle in terms of the review order.
That's all right, but now the.
So we have to look into that background.
That's correct, but this, how does one interpret this second part of clause 24? There are three important things here.
Yes.
You may not be able to give a full-fledged answer today, but.
I'll take note of it.
Please take note. Because Mr. Saikia, whichever way the outcome of the proceedings goes, we have to write a judgment.
Lordship.
Which is in consonance with the settled legal principle.
Absolutely, Lordship.
It says all teachers whose services were provincialized prior to 23/9/2000.
That is the date of annulment of the act.
Yes. So that means 1/1/2006 to 23/9/2016, a number of.
No, from 2011 onwards.
2011, all right.
Yes.
So 2011 is definitely after 1/1/2006.
Yes.
1/1/2006.
But their provincialization had taken place after the act came into force in 2011.
That is what I'm saying.
Yes.
1/1/2006 was a date even in the.
Even the earlier act also, yes.
Correct.
The repeal act also.
Correct. The 2001/2006 was a date even in 2017 act.
Absolutely not.
Problem arose when amendments came in. 311 was brought in, where a rider was put in that not only 1/1/2006, you have to get the permission, establish it 1/1/2006 prior to that. But even the provincialization sanction has to be communicated before 1/1/2006. That is when the problem starts. Otherwise, nobody has any problem with 1/1/2006.
There is another problem. The Dias Code registration of 2019.
We'll come to that. We'll come. So everybody is in agreement that any school not established prior to 1/1/2006 cannot, an establishment after getting permission from the statutory authority, cannot, the teachers cannot claim for provincialization. We don't think anybody is asking for that.
Amendment কোটা নিলাম amendment it could be নতুন একটা lordship, yes.
Right. So just highlighting the issues. Now, here, two things we find that provincialization prior to 23/9/2016. So definitely it includes provincialization which have happened after 2011, after 1/1/2006 till 23/9/2016. That means definitely provincialization have happened where permissions have been received or not permission, the
Recognition.
recognitions have been after 1/1/2006. Otherwise, 23/9/2016 is a redundant expression here. So therefore, all these things goes on under the 2017 Act, which means you are protecting rights of people till 23/9/2016. Then by amending 3(1), you take away that right. So constitutionally, what the state's constraints are, that is another matter. Constitutionally, what interpretation does one give to that?
I'll address on this also.
Secondly, their services are also subject to review.
Everyone's, yes,
Review
review.
by, as per eligibility norms set forth for provincialization. So review by whom?
There's a committee, lordship.
So does it mean that nobody is actually provincialized? It's a temporary provincialization?
Earlier on, earlier,
No, under this.
under this 2007,
Yes.
there is a process, lordship, that
The last 3-4 sentences.
of
You must have
24
noticed it, no? That
shall,
they shall continue and their cases shall be reviewed.
as per the eligible norms set forth by the provincialization under this act. So everybody has to apply afresh.
Apply
Before-
afresh for provincialization.
Yes, lordship.
But where is that provision?
That provision is there. The committee, detailed provision is there. It starts from 3, the additional qualification.
So are you saying that those 45,000 had to?
Yes. That is precisely the reason. Otherwise, if lordship looks at the review application, that order, it is very clearly mentioned there also. We have provincialized 41,000 persons from 2011 to 2016, 23rd September. Majority of them did not have the basic eligibility criteria qualification. So we have to review, and some of them have become tutors and some of them have become teachers now. Those who have qualified have all the eligibility criteria requirements. They are provincialized as teachers, and those do not have the qualification as per the various regulations. They are put into tutors category with a leeway to them that you procure this qualification within a period of 5 years, then your consideration for regular teachers will be considered. Those persons were reviewed.
Some 31 or 35,000.
41,000. 41,000.
No, left out was 33 or 34,000.
That was left out was different, but already who have got the benefit. If lordship is pleased to look at the review order, let us put
Yes.
that review
Let
order.
us have-
Page 165 of read petition 79 of 2022.
Yes. We may refer to the paragraph. We have a separate paper book here.
Page 165 is there.
Yes. Which para?
I starting the first paragraph. Order dated 2nd January 2017. This application is filed by the state to review, modify the common judgment and order dated 23rd September in WPC so and other cases to the extent that the services of the already provincialized employees of the education institutions will not be impacted by the court's order. The issue is to be considered here is whether the above verdict of 23/9/2016 will have prospective effect without implications for the already provincialized category, or alternatively, on account of our declaration that Assam so-and-so Act of 2011 is unconstitutional and void, all things done under the said repeal legislation since its inception, it sought to be not by the court's declaration. For deciding the state's application, we may benefit by referring to the law laid down by the Supreme Court when the court decided on the constitutionality of the law challenged in certain cases. Now skipping all this. State's consensus, paragraph 7. Page 17,
Yes.
paragraph 7 of the judgment.
Yes.
The state in their application submits that under the Repeal Provincialization Act, many employees and institutions were provincialized. Some of the beneficiaries have since retired, and if the government tries now to apply the judgment in letter and spirit, it would lead to a chaotic situation on account of resultant disruption of service for the already provincialized teachers and staff. Moreover, the government does not want to disturb this group as it is proposing to bring forth a fresh legislation to or rectify the already repealed defective acts by curing it of the legal deficiencies. So and so submits that if the judgment is applied retrospectively from the date of inception of the Provincialization Act, it will impact nearly 41,634 provincialized teachers and staff. Moreover, if the act is to be treated as invalid since inception, all the benefits who have accrued to the beneficiaries will have to be recovered and the status of the provincialized categories will turn into a private employee. The impact of those beneficiaries who have already superannuated from service will be harsh as their pension payments will have to be stopped. Similarly, wages for the provincialized staff cannot be paid from the government's coffer, and the question of recovery of already paid sum may have to be considered. So and so submits that the government is already working a fresh legislation after repeal of the Provincialization Act. Hence, the status of the already provincialized group should not be impacted, and this can be achieved by declaring the court's verdict will apply prospectively and not impact those who have already benefit under the repeal legislation. Then citing of the judgments. Now coming to the discussion part. Paragraph 17, Lordship. It starts from paragraph 12. I'm skipping those parts. The law. In the backdrop of the above discussion, let us now examine whether the equitable consideration should be applied in the present context. Because of the legal deficiencies of the Provincialization Act 2011, the legislation was declared as constitutionally invalid. The state considered to the legal defects and has decided to bring a fresh act to deal with the teachers and staff of the venture educational institutions of Assam. Therefore, provincialization of more persons under the proposed legislation is expected in due course. If that be the future scenario, those whose services were regularized through the due process under the recently repealed legislation deserve to be protected in the interim, since new act can legitimately address this contingency. As the litigants who challenge the virus of the Provincialization Act never desired disruption of the concluded rights of those who benefited under the Repeal Act. The state in its application have stated that the group they are concerned with those who have retired and are drawing pension, another category who are now government employees and are receiving regular salary of pay, and people of same classes who have moved on in their career or in life. There are around 41,634 employees for whom vested rights have already created under the 2011 enactment, though through retrospective applications of our 23rd September 2016, they may not only lose their government job, but also be disentitled to pension and salary. Moreover, the question of recovery of the already disbursed salary and pension may emerge. The harsh impact of the retrospective application will be crippling for the already provincialized group and their livelihood, and in turn, life itself will be adversely impacted. All such debilitating consequences will occur without any opportunity or hearing to this category. Many families depending on the earnings of the provincial staffs are enjoying a measure of social and economic security, and they all will be thrown to the streets without any fault on their part. In the above circumstances, we are of the considered view that rights of the employees who have been benefited under the struck down statute can be taken care of by giving retrospective effect to the proposed legislation if the legislature so desires. Till then, it is ordered that the services of the provincialized categories and their status as government employees shall not be disturbed, and they will continue to receive all the benefits they are getting under the Provincialization Act of 2011, since struck down by the judgment under review. With these observations and directions, the matter stands disposed.
All right, so that is why the question. So the legislature would be at liberty to give retrospective. effect.
Absolutely, Lord.
Until that happens, their services cannot be disturbed. That's
Lord.
the law. Now, has the legislature given retrospective effect to this act?
This one, no,
2000
absolutely no, or except the truth cutoff dates.
Mr. Saikar. Please understand the
Yes,
question.
retrospective effect, Lordship, there, what I'm addressing your Lordship on that. They were provincialized by various orders of from 2011 to 2016. Those are not in force. All these persons have to apply afresh before the committee, and fresh orders of provincialization are being issued. So it is prospective in nature, the act.
See, we are just trying to go by the letter of the judgments. You know, we are a coordinate bench. So
Lordship.
whatever is already on record, these will have to be taken note of by the court,
Absolutely.
right? And insofar as the statute is concerned, their interpretation is possible, but court orders cannot be interpreted. It has to be accepted by letter. Now, the para 19 of this review clearly says that it is open for the legislator to give retrospective effect to the new act to cover the interest of these people. But till such time it happens,
Yes,
their salary, etc., their service benefits, etc., nothing under the Act of 2011
Lordship,
shall be disturbed.
Lordship.
Correct. So let us take this para 19 as it appears.
Lordship.
The idea appears to be, subject to what you say, is that let the legislature pass a law to protect the
We,
provincial-
that was not given. We had the intention. We did not have the intention to give retrospective effect.
But then in that case, this order will continue to hold the field.
That is why the it will continue till the new legislation comes.
Please read it once again. Para 19, please kindly read it once again. See, we are troubling you with this.
No,
because
Lordship.
your
This is a very
response is
interesting and
very-
tricky situation.
We have to deal with this.
Yes, Lordship.
Please see
Yeah,
para 19.
I'm
once again.
coming, just giving the word.
The
In
fine
the above,
print, we are talking about the fine print. Now it's time to go into the fine print of these orders, these observations.
in the above circumstance, we are of the considered view that rights and employees who have benefited under the struck down statute can be taken care of by giving retrospective effect of the proposed legislation if the legislature so desires. Till then, it is ordered that, but we did not desire. The desire is not there.
So it was not given retrospective.
No. Absolutely no, Lordship. What we have done is that a fresh legislation has been, if we give retrospective, it will be overcoming the judgment of 23rd of September. In that case, we considered before the Honorable Court that all these persons are not qualified to be teachers. How can government, by bringing 2017 legislation, validate it? That is why we said we'll review.
Very well. Then we have to go to clause 6, General Clauses Act. Then we have to go to this. Let us mop up this part.
Yes.
Because we are now on this. There's a state act also. You have a copy of the state General Clauses?
Yes,
Act?
yes, I have, Lordship. Oh, state, it is there only. The language will be parametric.
It's parametry, yeah?
Mm.
Parametry. You have a copy?
I have the central
You
general clauses.
can take this.
It's gonna say that. What is? Application. কোনটো সেকশনটা উলিয়াই দিয়ে
Would you want a copy? of the,
It is given, Lordship. Yes. Lordship, effect of repeal.
Yes, let us read it this.
Effect of repeal. Where any act repeals an enactment hitherto made or thereafter to be made, then unless a different intention appears, the repeal shall not revive anything not in force or existing at the time at which the repeal takes effect. Alter the previous operation of any enactment so repeal or anything duly done or suffered thereunder. Any right, privilege, obligations, or liability acquired, accrued, or incurred under the enactment so repealed or affect any penalty, forfeiture, punishment incurred in respect of any
So these
offense.
are not material. We are
Yes.
on 6C.
C.
Yes. So
Affect
how
any
to
right.
reconcile these.
Where any act repeals any enactment hitherto made or unless a different intention appears, the repeal shall not affect any right, privilege, obligations, or liability acquired, accrued, or incurred under any enactment so repealed. It is a case where it is not repealed, it is struck down. The act has been struck down. Repeal we could have done on our own. Here, 23rd September 2016, the Honorable Court struck down the act as ultra virus.
Then why you have 24?
24, it is.
Mr. Saikya, we don't want you to respond today.
Then,
All we want you is to
then
just to take
I have noted,
These
Lordship.
are very subtle things. Very subtle things.
They are second part.
And
So
these will have a relevance. in
the
our-
intention is very clear. The language here of section 24 is very clear. All the teachers whose services were provincialized prior to so and so shall continue and their cases will be reviewed as per the eligibility norms set forth for provincial under this act. So not a single teacher will be thrown out. Whatever benefit they have got, they will get, but under the new eligibility criteria. That is why this tutor and teachers category have evolved. They got the right of provincial earlier. Now, only thing is that they have to segregate themselves as per their basic eligibility criteria regarding the educational qualification for holding the post of teacher. That is why is this section 24 also does not preclude anybody who have already attained some benefit under the Provincialization Act of 2011. They got the benefit as teachers, but here somebody will have to give way to become tutors because they do not have the basic qualification, and on that criteria only the 2011 Act was set aside by this Honorable Court. Direct conflict with all the legislations. In fact, I was arguing the case. I considered the case. NCT regulation, 2010 UGC regulation, everything was bypassed. Ultimately, what are all these? These are all various political interests are involved in provincialization. Nothing else. We are damn against the whole. If Lordship set aside also. But I am defending it, Lordship. On a lighter vein, I can say if it is set aside, the government will be more than happy because lot of public fund is being used and these schools, that is why we want to check the mushroom growth of this kind of schools at all. They must have basic infrastructure and the qualified teachers in their payroll. That is why all the good private schools are, they are not before this Honorable Court. They do not want provincialization. They manage their own affairs. These schools are basically for some commercial interest. The very hard statement again I am making. But these are the hard facts. Only thing is that being a welfare state, we have to think about certain persons. But this basically, this provincial whole act is more like an employee-centric, not student-centric. That is why the 2011 Act did not consider all the eligibility criteria of the teachers who are going to teach the tiny tots, whose whole future will depend upon the future course and course lining of the whole nation. Nobody, no well-informed and well-resourceful person will send his teachers to this persons will send their kids to these schools. That is why some of are having problem, that why 4 teachers were not provincialized, because they do not have the number of students. There is no bar. Give us the number of pupils accordingly, that you have the number of teachers whose services will be provincialized. They do not have the number of teachers, adequate students, and they are asking for more teachers. So I'll address on every issue, Lordship. We have a very good case. In fact, we argued, but I have to take your Lordship to some of their documents, which are very important. That itself discloses what they are submitting is totally against their pleaded case. And this particular section 24, it is precisely to protect their interest. If tomorrow, if somebody is unhappy that they want also the post of teacher and not tutor, that is also one of the challenge.
Yes.
That is also challenge, apart from the pay scale issue. If Lordship set aside tutors, then all tutors will go away. This will be a self-defeating argument for them. Or else they have to make all the other tutors who are not before this honorable court a party respondent sitting in my side, because their career will be adversely affected. Because somebody have to accept that at least government is giving some benefit to them by considering, because this tutor word is Lordship will not find in any educational legislation of the country. This is our innovation.
It is there in the.
Tutor in a different context. Here it is in a different context. In the other context, it is regarding various qualification, etc. Here, in the primary school, secondary school, there is no post of teachers, assistant teachers like that.
So here they are like.
In medical college, Lordship have demonstrators, registrars, etc. These are all academic.
Here they are like sub teachers.
Not actually, they are just allowed to come to the school and help. Ultimately, they may be teaching, they may not be teaching, but at the end of the day, what we are doing, it is against the students, be it the government also, and be it them also. We are allowing our future generation to be taught by undeserving and unqualified teachers.
Then why are you doing it?
Sometimes, Lordship, we have to do because we have given them the handle to get qualification in 5 years' time. If they are serious about, they would have rather go to the B.Ed college or whatever educational they have to acquire.
So if they acquire the qualification,
Yes,
then
they will become teacher. Possible kindly allow to stop me today. I'll address on all the points, whatever has been argued by the other side and indicated by this honorable court also.
So then this goes after vacation.
Lordship. I'm sorry, Lordship. Even otherwise also, if I do it day to day also in 3 days, it will not be possible to complete by Friday. Otherwise, I would request my colleague advocates to argue the case, but it will not be completed. Because lot of sections, lot of materials we have to place to convince this honorable court and to give the complete and correct picture.
So that is what is important.
Absolutely, Lordship.
What is important? We would like to know what exactly is
The story is totally different. They are giving a one-sided of the story, but the story actually is that government wants to stop this whole business of having venture schools. There is no shortage of school in Assam. Absolutely no shortage. And now the government schools are doing very good results. If Lordship looks at the last 1 or 2 years results, the trend is changing. So we have to have proper qualified teacher in the schools, and for that there is no shortage of fund. But to give benefit of some family business, it is always.
Like we have said, we are not on the wisdom, we are only on the constitutional.
But still government has done it, so we have to take the cue from the 2011 Act. So we have gave him the commitment to the honorable court. That is why we are.
That the government would not have any problem if this act is also struck down. Is that a serious statement?
No. Because this act, this government has brought in, Lordship, we do not want to get it stuck up. We'll defend the act, Lordship. Put and nail. Earlier we considered, because prima facie, there is no requirement of educational qualification. Somebody writes that he is working from such and such date. More sympathetic than objective. We are already suffering from what has been done from 1991 to 2001. That 10 years period ruined the education system
So
of Assam.
we are just asking you a question. If you could obtain instruction on that. Other things we'll see. But on the proviso to amended 311, there you are eliminating those schools and those teachers which were established prior to 1/1/2006 by obtaining permission from the statutory bodies. Their recognitions were in this pipeline, which were halted for whatever reason. And those recognitions either came after 1/1/2006 or never came before because of this. So is the government open to address their issues by? If
No, no.
necessary,
What I am saying, Lordship, that on 1/1/2006, why they have not received the recognition, it is not the fault of the government. It is the fault of the school. They could not fulfill all the requirements to get the recognition. That is what I am trying to impress upon this honorable court. Just 1 month, 2 months prior to that cutoff date also regular.
Right. That is a fact-based stand.
Yes.
But here we are concerned with a statutory provision, which initially was open and then by an amendment, a cap has been brought in. So please understand this, Mr. Saikia. I mean, we are sure you will, when you find time to apply your mind, you will go into the subtle aspect of this.
Yes,
matter.
yes, Lord.
We are not at all on the wisdom of the enactment. The state is the best judge what is to be done. That is not the business of the.
When the amendment was brought at
See,
that
here
point of
there is a
time,
technical issue which the court is confronted with. You may have your arguments. We're not saying that. Those arguments may be valid and attractive also. But side by side, please examine this. This is a case where even 2017 Act did not bar them. What had taken away their rights is the amendment to 2017 Act.
I agree, Lordship. I
Right.
have understood.
So there we have a constitutional pitch. We'll seek your
Lordship.
assistance to handle
Lordship.
this. If a particular school was deliberately negligent, committed a fraud, that is another.
No, not fraud. I'm not saying fraud, but they have not done the requirements to get the institutions upgraded to get the recognition at that point of time. And when it is ultimately a government policy decision, we know how many schools we have to ultimately provincialize.
For policy decision, but by an act you have given it to them and then you have taken it out.
No,
away
we
by
have not, because at that point of time, the scrutiny was still started only. It is not that.
No, you have a look. You have
Nah,
another.
3 amendment.
Have a look at section 3 of the 2017 Act.
On the inception of it, this is the amended provision. From inception.
It is a subtle point here.
In my instruction is that I haven't gone through it right now, Lordship, but it was already there earlier also.
Saying when you find time, you just examine this
Yes.
little minutely and look at it from a constitutional point of view, not from what government thinks. or
Lordship,
government
no, no.
finds. That's another matter. But from a purely legal constitutional point of view,
Sure, Lordship.
we would request you to examine this matter. You bring in a cutoff date in the previous act, the grounds on which the act was challenged were considered. The same cutoff date remains in the amended act. Nobody has any problem, or even if somebody has a problem, that's another matter. So that lays down the framework that only 1/1/2006, prior to that, those schools were established by obtaining permission of the statutory bodies. Only they will be entitled to being considered for provincialization. To that extent, even 2017 Act is consistent.
Fine.
Then comes.
Because I have one information, it is also there, that lot of recognition orders were issued in 2009, 10, 11, giving a retrospective effect of 2000 prior to 1/1/2006. That is a fraud done by some of our officers.
Cancel all orders which are fraudulent, but.
How can today, if the recognition is to be obtained in 2006, everything was ready, the field is ready, they should have made the inspection, because inspection is one of the criteria, then only they will give the recognition. For that school, why this particular certificate was issued in 2009 or 2010, when they have done the inspection in much beyond 1/1/2006. So 1/1/2006, they must fulfill all the conditions precedents to get the recognition.
Mr. Sekhar,
Now-
that is the problem.
That
That is the problem.
that is
Why
why-
was the amendment necessary?
that is why the amendment was
Not necessary.
still we are saying the effect will not be different. Only thing is that there are a lot of certificates issued after 2006, 1/1/2006, in 2007, 9, 10, giving retrospective effect of 3 years earlier, 4 years earlier. An act can be given retrospective effect. How can a government's order can be given
Please
retrospective
understand,
effect?
please understand this. 2017, please please appreciate what we are saying.
Lordship.
We don't want an answer today, but we want you to think on these points and address the court. Third time I'm repeating, we are only on the constitutionality of these provisions, nothing else.
The constitutional
Government-
also,
Yes.
which constitutional provision we have violated?
That's what we are saying.
Which constitutional
You have 1/1/2006 as the cutoff.
cutoff
In
date?
the 2011 Act.
Yes,
that
and
remained
2017 also.
unchanged in 2017. So anybody who has committed a fraud or some kind of a malfeasance, misconduct of any nature, that although the school was actually not meeting the requirement of 1/1/2006, yet by circumventing the provision of statute, they got the permission subsequently, and the delay was only because they indulged in acts which was contrary to the provision of the Act of 1/1/2006. Those cases, you could individually reject them on those grounds. But the necessity to amendment came only because the idea was not to eliminate those schools which has indulged into malpractice, even those which did not indulge into malpractice. Otherwise, you don't need to amend it. If you do not amend the act, you can always eliminate those who are into malpractice. But you will need the amendment. only
I'll go through it minutely and
to
I'll
have
come
the
back to
most
this.
point.
Yes, Lordship. I will again minutely go through the amendment.
Only when you want to cut short even those schools which did not take part in any malpractice, but it was a pure act of ministerial delay.
No, our whole criteria is that the school which has got both permission and recognition prior to 1/1/2006. Are they suffering, Lordship? As simple as that. They are not suffering. Only thing is that some schools who do not have that recognition and permission on that particular date, they have recognition certificate issued after 2 years, 3 years, with a retrospective effect. So I'll try to address this honorable court's query after going through it minutely, Lord. I'll address it.
All right, so when it has to go after vacation,
I have no difficulty on any day. Lord.
16th onwards, we keep it. First day will not be 16th onwards.
Yes, Lord.
Or should we keep it on 15th?
15th also, no difficulty.
You take down Mr. D. Sekhar.
There may be some accommodation, maybe because I have 2, 3 matters fixed in court number 1 also. Accommodation means maybe
No,
for the
you
time
tell
being.
us on 15th, which part of the
No, no, no.
flow we will be in. In
From
Assam
10:30 onwards. 10:30.
15th or 16th?
Lordship will keep it on 15th also, no difficulty. Let it be on 16th Tuesday, Lordship, the hearing day.
Mr. D. Sekhar, and Advocate General Assam, has addressed arguments defending the constitutional validity of the statutory provisions under challenge. However, due to paucity of time, arguments could not be concluded today, citing personal difficulties over the next 2 days. Mr. Sekhar has made a request to the court to pose these matters for further hearing with effect from 16th of the further hearing in immediately on reopening of the summer vacations. Taking note of the request made by the learned Advocate General, we direct the registry to list these matters for further hearing. Subject to availability of the bench, we direct the registry to list these matters for further hearing. Again on 16/7/2024, the matters will be taken up for hearing on day-to-day
Lord.
basis.
I love.
Yes. Is there any other matter?